we will be presenting topic 9, negligent misstatement. Definition in negligent misstatement. Negligent is a failure to do some act which a reasonable person in the circumstances will do. A tort is defined as a wrongful act or omission which gives rise to a civil action in a court of law against the party that committed the wrongful act. The tort of negligence misstatement is defined as an inaccurate statement made honestly but carelessly, usually in the form of advice given by a party with special skill or knowledge to a party that does not possess the skill or knowledge. Now we will look into the essential element of the tort of negligence misstatement. There are four elements in the negligent misstatement, which is duty of care, breach of duty, causation, and damages. If the existence can be proved, the action in negligence will succeed unless the other party able to establish one of the defenses to the tort of negligence.
First of all, duty of care. The first element of determining negligence is whether or not the defendant owed the plaintiff a legal duty of care. There are situations where a legal duty is created in the relationship between the plaintiff and the defendant. A duty of care arises when the law recognizes a relationship between two parties, and due to this relationship, one party has an obligation to exercise the same level of reasonable care that another person in a similar situation will exercise. For example, all drivers are expected to maintain their vehicle in safe condition and operate their vehicle safely in accordance with all traffic laws. Business owners have a duty to take reasonable care to ensure their premises are safe for their customers and employees. This can include regularly inspecting their property for hazardous condition and fix it within a reasonable time frame. Next will be breach of duty. The next element is for the court to determine if the defendant breaches this duty by doing or not doing something that average person will do if they were in a similar circumstance. A jury might likely find a defendant negligent if an average person knew everything the defendant knew at the same time and would have known his or her action might cause an injury to someone else and would have done something different from what the defendant did in the same situation. Below are two examples in which a breach of duty has occurred. A company vehicle does not allow enough stopping distance when approaching an intersection and strikes another vehicle that was stopped at red light. Next, a dog owner knows their dog is very aggressive towards children, brings the dog to the T-ball game, and the dog viciously bites the child. Third will be causation. A proximate cause in event related to an injury that the courts feel to be the cause of said injury. It is an action that produces foreseeable consequences without an intervention from anyone else. Proximate cause is also known as a legal cause. An example of proximate cause is an ambulance flips over on the way to the hospital after aiding individuals in the different car wreck. There is no proximate cause tied to the car wreck that the emergency service were called it to initially. A party is not liable for harm sustained resulting from action taken as a result of initial causation. Last will be damages. Damages are the final element of negligence. Because the plaintiff suffer injury or loss which a reasonable person in that same situation could expect or foresee, monetary compensation may be the only form of relief for those injuries. Damages include medical care, lost wages, emotional turmoil, and more. For example, if the manager of a sports equipment store displays heavy medicine balls on a flimsy top shelf, the shelf collapses and the balls start tumbling down rapidly, striking a customer on the head and causing him to suffer a concussion. The customer has to miss several weeks of work and receive hospital bill. Monetary compensation will be compensate the customer for his injury, lost wages, and medical expenses.
Moving on to 1.2, what are the preconditions for liability? Liability in tort for negligent misstatement can rise only in the following circumstances. First, where one person owes a duty to another person to exercise care. Second, the duty of care has been breached. For example, the maker of the misstatement has been negligent. Third, if the statement was not made as an inducement to act whether it was reasonable for the recipient nevertheless to rely on it. Lastly, the person has suffered loss or damage as a result of relying on the misstatement. There are 5 types of liability. First, psychiatric injuries. Second, economic loss. Third, occupier liability. Fourth, product liability. And 5, strict liability. A recognized psychiatric illness that is caused by sudden shock as a distinct from normal grief, sorrow, or anxiety. There is no general duty of care for psychiatric injury. Claims for psychiatric illness are similar to physical injury claims in that the psychiatric illness must be as a result of someone else's negligence and should be brought within 3 years of the date of the accident. These are the types of psychiatric injury. The approach to these types of claim differs depending on whether a person is considered first primary victims, someone who has been directly involved in an accident, secondary victims. These claims are less straightforward than those involving primary victims. Second is economic cost, where a defendant has injured the property or person of a claimant and consequential economic loss occur. The law of torts will allow compensation. Liability for economic loss will be imposed where a defendant has knowledge or the means of knowledge that the claimant is likely to suffer loss as a result of the defendant's act or omission. In terms of pure economic loss, the use of the word pure tends to suggest that the loss in question must be untainted and stand apart from the other types of loss suffered by a claimant in any particular case. In a claim for personal injuries following negligence by a defendant, the claimant may well be unable to resume work. Third is occupier liability. Occupier liability is when an owner of private land or property, such as a business, shop, restaurant, or sports center, for example, is liable for any injury caused to a person on their land as a result of poor maintenance or poor design. These are the examples of occupier liability claims. Proof the land you were visiting was unsafe, you will need evidence. First, photographic evidence. Second, witness statement. Third, photographic of your injuries. Next is product liability. Product liability is the area of law in which product manufacturer, distributor, and sellers are held responsible for the injuries caused by their product. There are 3 main types of product liability claims. First, design defect. Second, manufacturing defect. Third, marketing defect. Lastly is strict liability. In tort law, strict liability is imposition of liability on a party without a finding of fault. The claimant need only prove that the tort occurred and that the defendant was responsible. Strict liability applies in these 3 categories of cases.
1.3 Exclusion clauses and disclaimers. A disclaimer or exclusion clause is a term of the contract that either limits, excludes, or restricts liability of one party against another for either breach of contract or liability for negligence in a contract. For example of the case, in the Hadley-Bryan case, Hadley-Bryan had requested its own bank to inquire through a second bank on the financial stability of a company. The second bank prepared a report upon which Hadley-Bryan acted, but lost money as it contained erroneous and misleading information. The second bank headed its report with the words, "For your private use and without responsibility on the part of this bank or its official." In view of these words disclaiming liability, the House of Lords held that no duty of care was accepted by the second bank and none arose. Therefore, the claim by Hadley-Bryan for damages to compensate for financial loss resulting from negligent misstatement failed. This disclaimer was effective to exclude any liability and claim against the bank. The disclaimer of liability was effective because it destroyed the very thing from which liability was said to flow, an undertaking to apply skill or a holding out of skill or circumstances arising, such as that a person will reasonably rely upon the advice given. A person giving advice may be able to avoid liability if before or at the time of giving the advice, the person makes it clear that he or she accepts no responsibility for his or her statement. A disclaimer may be effective for misstatements made negligently, but not the ones made dishonestly. There are some points to be remembered about disclaimers. First, disclaimers will always be construed against a party trying to rely on them. The second one is, the more tightly worded disclaimer, the more strictly it will be construed. If a disclaimer is very broadly worded, it will probably be too general to be effective. If it is very tightly, so that it covers everything and attacks the head of the relationship between parties, it may be held to be ineffective. So, an effectively drafted disclaimer will fit somewhere between these extremes. Where a contractual relationship exists between parties, it is possible for them to agree in their contract that neither one will be liable to the other in specified circumstances. There is no reason in principle why liability for negligent misstatement cannot be effectively excluded by a clause in the contract. For example, an exclusion clause.
2.0 Statutory liability. Statutory liability consists of four elements, which are: number 1, civil liability imposed by statute; number 2, Capital Markets and Services Act 2007; number 3, Companies Act 1965; number 4, reasonable basis and know your client rule. Civil liability imposed by statute. What we have considered so far has been liability for misstatement imposed by common law. Remedies for losses arising from misstatements by licensed persons, however, are also available under statute. Liability for misstatement under the CMCA Companies Act 1965 and specific provisions for misleading recommendation, however, warrants closer examination. 2.1 CMCA Capital Markets and Services Act 2007 contains a number of provisions which cover liability for misstatement. Section 177 prohibits the making of a statement or the dissemination of information that is false or misleading. Section 178 prohibits a person from fraudulently inducing another person to deal in securities. Section 179 prohibits a person from making untrue statements or omitting to state a material fact for a purchase or sale of securities, or from using manipulative and deceptive devices. Section 199 imposes civil liability on a person who contrives. Section 182 imposes criminal liability on a person who contrives. If a person suffers a loss or damage as a result of behavior that would constitute an offense under Section 177, 178, 179, that person can bring an action for compensation under Section 199, whether or not the other person has been charged or whether or not a contravention has been proved. In addition, civil liability can arise concerning recommendations by licensed persons or any other persons. 2.2 Companies Act 1965. Companies Act 1965 contains certain provisions for which civil rights of action are given to persons who have suffered a loss. These are as follows. Section 46 gives subscribers or purchasers of shares or debentures who act on the basis of a prospectus a right of action against the directors, promoters, or other authorizing the issue of the prospectus to obtain compensation for loss or damage sustained by reason of any untrue statement or willful non-disclosure of a material matter in the prospectus. Section 364, 362A, and 366 also impose criminal liability for false and misleading statements, false reports, and fraudulent inducement of people to invest money.
2.3 Reasonable basis and know your client rule. Firstly, liability. This section reads a licensed person liable to compensate a person if the licensed person has made a recommendation and has not disclosed the nature of any relevant interest in or interest in the acquisition or disposal of the security. Such interests include the fee or benefit, for example, underwriting fee, the licensed person will receive, whether directly or indirectly, other than a commission or fee from the client arising from giving the advice and that may reasonably be expected to be capable of influencing the advisor in making the recommendation. Make a security recommendation to a person who may reasonably be expected to rely on it without having a reasonable basis for making the recommendation. Second, defense. It is a defense to a prosecution for the contravention of Section 91. If the person making the recommendation did not know and could not reasonably have been expected to know of the interest when making the recommendation. If the person was merely a co-director and was involved in the making of the recommendation. If a reasonable person in the client's circumstance will have done the act in reliance on the recommendation even if the listened person had complied with Section 91 or Section 92. In summary, we began this topic by considering the thought of negligent misstatement. It is only in recent years that the thought of negligence has been applied by the court to the written or spoken word of a licensed person. We discussed the element of the thought of negligent misstatement. In the security industry, damage for the thought of negligence usually arises from a misstatement, rather than an action that is negligent result in a financial rather than physical loss. We conclude this topic by looking at the additional liability for damage imposed by statute. In particular, the CMSA concerns a licensed person who makes a recommendation about security to a person who may reasonably be expected to rely upon it without having a reasonable basis for making that recommendation. That's all for my team. Thank you.